here because one of the participants drafted me to this subject matter last year, and Kathy Bellman, they can blame you if they don't like the particular judicial canons of ethics we are going to discuss, because I have Catherine to thank for that, and being the good sport she is, she made sure I didn't speak by myself this year. We're going to be talking about three really interesting ethical canons that I think anyone with either a trial practice or a corporate practice, or certainly representing lawyers or professionals as I do from time to time, might be interested in. Sarah has some additional copies of the particular canons. Let me do some disclaimers and ground rules first as she passes them out. I don't use a lot of bells and whistles. I just use the rules themselves. We'll talk about the rules. We'll talk about, I think, the comments that support the rules. I don't know if the comments are included. That's fine if they're not, because then you have to listen to me. We'll talk a little bit about commentary. Those of you who still use books, I was over at the law library just this morning at the Capitol, and you can get the ABA's Lawyer's Desk Book on Professional Responsibility, or you can probably look it up on the internet. That's the ABA puts out all the commentary you could possibly need on any of the ethical canons. And then, of course, it wouldn't be a Nebraska seminar if I didn't cite at least a couple of Supreme Court cases that we'll talk about, and then at least one U.S. Supreme Court case. We'll talk about the first rule for the first hour, and then we'll break at 3. And then Sarah reminds me that we will be done by 4 because this is a Bar Foundation room, and they want it at 4. So I will not go over time. You may be comforted to know. I invite you to ask questions at any time. And I'll try finish up on one of the ethical canons like toward the end of the first hour, so I can provoke questions. I would certainly expect with contemporaries like my friend Scott Helvey or Michael Gooch, I can certainly rely on you to provoke questions from time to time. If not former students of mine like Mr. Brown or Mr. Austria, I'll be sorely disappointed, gentlemen, if you don't interrupt me with questions. I'd appreciate if you save all the hard questions until after I left. But other than that, we'll assign Mr. Helvey the post question mortem down at a local bar or something at the end of today. I'd like to get an idea of who I have here. So how many of you are what you would call just general trial attorneys like myself? Who are the trial guys? All right. Corporate transactional folks. And any people who represent agencies? Very good. Very good. I think there's something here for all of you when you talk about candor in the courtroom, because the courtroom extends beyond the formal courtroom to mediations, to any transactional decision-making body as far as these particular rules. And then I can, well, let's just move to Rule 3.503. First of all, the candor toward the tribunal. That rule is really, I think, going to provoke most of the first hour of discussion because it has the most various inner workings as far as the courtroom lawyer. I note, first of all, that there are, in just kind of looking at the rule overall, there are 3 categories of representations lawyers make in the courtroom that the rule breaks down to. The lawyer's himself or herself statements to the court. The lawyer's representations regarding legal authority as far as the obligations to fully disclose that, and then the lawyer's obligations as far as what the lawyer's client or witness says to the court. And I think it's important as you look at the rules to look at all three of those different inner workings. Then I think critically, to help us understand as we go through it, you look at the comments to the rule to understand the import of the rule itself. And then finally, like I say, I'll have a couple of relatively recent Supreme Court cases in Nebraska. So let's begin first of all on 3503.3, the candor toward the tribunal, the candor obligations of the lawyer in the tribunal setting. A lawyer shall not knowingly, 1, make a false statement of fact or law to a tribunal or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. 2, fail to disclose to the tribunal legal authority in the controlling jurisdiction known to the lawyer to be directly adverse to a position of the client and not disclosed by opposing counsel. Or 3, offer evidence the lawyer knows to be false. So before we get into the comments to kind of understand that, note that the first part of it, that you, the lawyer, knowingly, in 1, make some sort of false statement as to fact or law. That's the first admonition. 2, your obligation is to be proactive, to disclose, and failing to disclose to the legal authority in a controlling jurisdiction. And then 3, your obligations as the advocate, as the representative of the witness, to in any way be a part of offering false or misleading testimony. All right, so again, let's look at the comments to kind of understand the import of the rule as far as the responsibilities of the lawyer himself or herself. Comment 1, talking about the rule governing the conduct of a lawyer who is representing the client in the proceedings of a tribunal. And important to recognize, the rule applies to a tribunal broadly. It also implies when the lawyer is representing a client in an ancillary proceeding conducted pursuant to the tribunal's adjudicative authority, such as a deposition, so it extends beyond the courtroom into the deposition process, and requires a client to take reasonable remedial effort if the lawyer knows or comes to know that a client is testifying in a deposition in a false way. So I suggested we'd have a Nebraska case. Let me look at an example Nebraska case as far as the application of the rule as far as a misrepresentation outside the courtroom. First Nebraska case I want to then refer to is State versus Christopher Plumfeld, the respondent. And let's see, this is found for those of you who take cites at 287 Nebraska 129. And the application of, again, the lawyer's obligation in a context where I think the fun thing about this case is it illustrates a situation where sometimes the lawyer representing himself has the proverbial fool for a client. So in Christopher Plumfeld, we have these facts in terms of the court's analysis that the respondent admitted to practice in Nebraska in January 17 of 2000, found himself charged in the county court of Douglas County to collect on a plumbing bill incurred by the respondent in the amount of some $1,158.96. So he first filed a motion to dismiss, alleging that the county court for Douglas County lacked jurisdiction because the plumbing services were contracted for and provided for with respect to property owned by a respondent in Saunders County. You had the wrong county. And then he also, on schedule on the motion, represented that the attorney representing the credit bureau, in the motion to continue the hearing on his motion to dismiss, had failed to serve him properly with the motion to continue. There was a second attorney appointed, and our respondent used similar tactics as far as saying, you don't have jurisdiction over me because I was not properly summoned to this hearing, I wasn't properly noticed. He moved his law office in the course of this, so he complained service was at a law office in the first instance and not at the second. What happened in Plummer, ultimately, as far as the analysis, is he was disciplined. He was found to have violated the rule as far as a false misrepresentation to the tribunal. The charges, as the Supreme Court found against the respondent, essentially alleged that the respondent failed to advise the first attorney of his change of address, but nevertheless complained to the court and counsel for discipline that the first attorney was falsifying the certificates of service. They found no basis in fact whatsoever to advocate that position. At his disciplinary hearing, he failed to establish a factual basis for that sort of rhetorical motion complaining about opposing counsel. Hence, that false representation of both the lawyer himself as the client to the court. So that's an example of this rule application in that first Nebraska Supreme Court opinion I promised to cite you. But let's go back to comments under the rule to better understand the rule in its practical application. Representations by a lawyer, an advocate, the lawyer, is responsible for pleadings and other documents prepared for litigation, but is usually not required to have personal knowledge of matters asserted in those pleadings for litigation. As far as then legal argument and your obligations of candor to the courtroom in the course of legal argument. Legal argument is based on a knowingly false representation of law constituting dishonesty toward the tribunal. A lawyer is not required to make a disinterested exposition of the law, but must recognize the existence of pertinent legal authority. Furthermore, as stated in paragraph A2, the advocate has a duty to disclose directly adverse authority in the controlling jurisdiction that has not been disclosed to the opposing party. It's interesting as far as the comments you have toward disclosing legal authority. And looking at the knowingly part as far as the preamble to the rule itself. So I suggest as they struggle with this application, you would have to establish as far as disclosing adverse legal authority and knowing legal authority that the lawyer actually had knowledge of or had that sort of intentional misrepresentation to the tribunal as far as legal authority. I think facts, disclosure of facts are a very different proposition under the rule. And let me sort of transition now to what I think is a good reason that people like Mr. Gooch are here. I think the criminal lawyer, the criminal defense attorney, has an unusually significant responsibility, as well as the prosecutor, as far as the obligations upon the lawyer representing the criminal client, as far as suborning perjury or in any way condoning a misrepresentation of fact to the court, while all the while recognizing that you have the privilege against self-incrimination, and not only can you not be required to testify in the criminal proceeding, but you also have, conversely, the criminal defendant wanting to testify, and then you ask yourself as the criminal defense attorney, how much do you know, how much has your investigation disclosed as far as questions that relate to the guilt or innocence of your client? And that's where the rule
really becomes tricky, and I think provides the more interesting discussion as far as the obligations of the candidate. Let's go back to the rule itself as far as offering evidence. And so we go back to 503.3 and subpart 3, offering evidence that the lawyer knows to be false. If a lawyer, the lawyer's clients, or a witness called by the lawyer has offered material evidence and the lawyer comes to know of its falsity, the lawyer shall take reasonable remedial measures, including, if necessary, disclosure to the tribunal. A lawyer may refuse to offer evidence other than the testimony of a defendant in a criminal matter that the lawyer reasonably believes is false. And that is also one of the preambles under that feeler. Again, the overarching obligation is offering evidence that the lawyer knows to be false. That's the prohibition, that's the rule. B under that, a lawyer who represents a client in an adjudicated proceeding and who knows that the person intends to engage or is engaging in criminal or fraudulent conduct relating to the proceeding shall take reasonable remedial measures, including, if necessary, disclosure to the tribunal. How do you interpret that? Well, let's look at some of the comments under that. For example, let's talk about the lawyer's client in a criminal proceeding testifying falsely. Under comment 6, under that rule, if a lawyer knows that the client intends to testify falsely or wants the lawyer to introduce false evidence, the lawyer should seek to persuade the evidence should not be offered. Okay, so that's I suppose easy enough. If you recognize in your counseling your client that he or she wants to testify to something you know to be false, you need to dissuade that. If the persuasion is ineffective and the lawyer continues to represent the client, the lawyer must refuse to offer the false evidence. If only a portion of a witness's testimony will be false, the lawyer may call the witness to testify, but may not elicit or otherwise permit the witness to present testimony the lawyer knows is false. Let me just kind of ask the rhetorical question, because we'll come back to that in looking at some cases. Think of the quandary that puts you in. Think of the client who still wants to testify, and you're my lawyer. I want you to put me on the stand. 7, under the comments, gives us a little more guidance. The duties stated in paragraphs A and B apply to all lawyers, including defense counsel in criminal cases. In some jurisdictions, however, courts have required counsel to present the accused as a witness or to give a narrative statement if the accused so desires, even if counsel knows the testimony or statement will be false. The obligation of the advocate under the rules of professional conduct is subordinate to such requirements. 8, the prohibition against offering false evidence only applies if the lawyer knows that the evidence is false. A lawyer's reasonable belief that evidence is false does not preclude its presentation to the trier of fact. A lawyer's knowledge that evidence is false, however, can be inferred from the circumstances. And then let me just read 9 in the comments under the rule. Although that paragraph A3 prohibits the lawyer from offering evidence the lawyer knows to be false, it permits the lawyer to refuse to offer testimony or other proof that the lawyer reasonably believes is false. Offering such proof may reflect adversely on the lawyer's ability to discriminate in the quality of evidence and thus impair the lawyer's effectiveness as an advocate. Because of this special protection historically provided criminal defendants, however, the rule does not permit a lawyer to refuse to offer the testimony of a client where the lawyer reasonably believes but does not know that the testimony will be false. Unless the lawyer knows the testimony will be false, the lawyer must honor the client's decision to testify. That's got an interesting, and let me go to that promise of some Supreme Court interpretation as far as that part of the rule. The constitutional obligations and how that rule changed over time. And here I'm going to be referring, as I told you, to that handbook developed by the ABA. If a client is a person who is considering committing perjury, the client will have no trouble figuring out how to do so without triggering disclosure by the lawyer. The lawyer is practically inviting the client to lie. That's the criticism of the rule. The best way to prevent the crime of perjury or fraud is to tell the client that if the
a state or federal constitutional guarantee. Consequently, some commentators have argued that the accused should have a right to testify, and to testify falsely without his or her lawyer revealing the client's perjury. The comments to 3.3 acknowledge this position and deal with it by providing that if a jurisdiction imposes a different rule or requires, as a constitutional matter, that the lawyer present the accused as a witness, then if the accused wishes to testify, even if counsel knows the testimony will be false, the lawyer must follow the constitutional requirement. I don't know of any decisional law in Nebraska on that point. Do you mind?
I don't. But I do know that there's been some discussion of a sort of related question, and that is the defendant who's going to take the witness stand and say, I didn't do it, is treated differently than the defendant who takes the witness stand and says, I was with Bob on Tuesday. The one is a denial of a government accusation. The other is an affirmative fact that may be false. And the distinction between the two, I think, has made some difference.
Oh, yeah. Yeah, no, and I can see, and I think we all can at that point, that first of all, is it a statement of fact, or is it, like you say, a legal denial of an accusation of the state? So if the county attorney has charged you and you say, I didn't do it, that is a much broader and really constitutionally privileged position to take than suborning a statement that you know to be false. Yes, sir.
Something worth pointing out, that distinction is a good one, and it's often lost on your client. Your client comes in the door knowing that he doesn't have to say anything. He's entitled to simply be silent. And I've had clients honestly believe that since they don't have to say anything, they can also lie.
And your practice is what, sir?
On a criminal
defense.
trial.
And trial, yes.
Yeah. Because I don't have to say anything, I can tell a fib and it's okay. You know, you got to counsel them against that.
Oh, yeah, I mean, and we'd be naive to think, I'm sure prosecutor or defense counsel alike would remind us that certainly there are some sophisticated clients in terms of that they've been around the block as far as the court area.
From a practical standpoint, at first blush, I would be inclined, if this circumstance came up, and I do civil work, I would be inclined to withdraw from the case due to conflict. My question is, though, does anybody have experience, or do you know, what are judges likely to grant your ability to get out, or is the thought, or are you kidding me, the next attorney down the line is going to have to do the same issue?
What's the predicate to your notion to withdraw? Are you going with our hypothetical here that you know the client sat down and you know the client wants to testify and he or she wants to give testimony that you know factually to be false?
Correct.
And you do not want to, under the rule, you say, wait a second, you know, that's a 3.3 violation. And so therein it does give us an ability to withdraw, I believe, and as long as you're not, I don't think you have an affirmative obligation beyond your withdrawal to disclose that, because that's a tactical thing. That's not like the client telling you he or she's going to commit a crime. But, and I do think the rule contemplates you being able to go to the court, and some of you who may have had that situation, does anyone have an experience of going to a district judge and saying, Your Honor, I need to withdraw because I'm put into this ethical quandary. I obviously can't say anything about it, but my client wants me to do something I cannot do as a lawyer. None? Yeah. Yeah.
Simply alleging that continued representation of violent code of professional responsibility period, the granted judges don't question that concerning that assertion that the officers of the court may assume that we have a legitimate reason we don't disclose the nature of the reason.
Yeah.
A variety of different reasons that we are not free to disclose because of the obligation to maintain secrecy.
Yeah. And I do think it's a practical matter that is the solution there. You're out and you go go to the
You know,
court.
in trial, I deal with more difficult.
Yeah,
Come down to the question.
that's when it's really tough.
But-
So your counsel there, Scott, would be, for Guy's sake,
And I think that we like this one. I said to the judge, I cannot tell you the reason.
Yeah.
Code of professional responsibility, disclose the reason. I believe that I, good standing with that judge, my confidence in that.
And I've got the contrary experience, gone to the judge and said, I can't continue because of the rules of ethics. And the judge said, sure you can.
yeah.
And then you get into all these hair-splitting problems of putting the client on the stand, knowing that they're going to tell the truth about their name, they're probably going to admit that it's Nebraska, and, you know, the third or fourth question in, you start to have belief versus knowledge problems, you know, so you have to figure out how do you do a direct examination without stepping over the line. But I've had Scott's experience many times.
Yeah.
Got a problem, got to let me out. But I've also been appointed, since I left the public defender's office, a number of times where the judge will call or the panel administrator will call and say, we need to appoint someone who's hard of hearing because you'll be the fourth lawyer. Read into that what you need to read into that. Then you go talk to the client, and then you know what's going on. And you know the lawyer after you is going to be in the same spot. So you have to face that because somewhere along the line, the judge goes, I'm not going to appoint any more lawyers. Do the best you can.
This duty is part and parcel of my colleagues. I remember talking to Jerry Susi a year ago when I first did this Stafford about, because a lot of my colleagues who do nothing but a criminal practice will tell me, you know, there are reasons I don't want to know from my client. From my client's point of view, whether or not they committed a crime. I want to do my own independent investigation, and I want to object. So I don't ask them. I don't ask them
Certain questions from intake on. And I do my own investigation. And then when we come to certain points in time, then I have that. Now, I don't know if that's common practice, wise practice, but it's this area of the code really prevents a lot, I think, tougher situations for the criminal defense counsel than does the civil. We'll talk a little bit about civil duties of disclosure, discovery, and things like that apply to civil trials also. But the penultimate rub of the client's ability to take the stand, you know, the corollary of you don't have to, but if I do, I want to tell the jury before they determine the question of guilt or innocence. And the lawyer having information independently or from however gathered, objective information that the client may testify falsely, factually falsely, is a conundrum. Is a tricky situation there.
And thinking about this more, I might even now be more inclined to try to withdraw if it got in that circumstance. Because at least later on, if the judge didn't let you out, at least you could, if an ethical complaint came out, you could think, look, I tried.
Well, and the two examples you heard today, illustrate whether it's, you know, Mike getting appointed 4 times over the. You really need to kind of prep your case, and if you have a situation where you're concerned that the client may be wanting to testify and present illotribunal false testimony, you better get at it before the eve of trial or the second day of trial, where we all know judges are strongly disinclined to stop declare the mistrial and move on to do it again another day. That's Iris' question back there.
I think the problem with the withdrawal thing is really twofold. When you withdraw for reasons you won't really specify, you leave suspicion on your client in the eyes of the court, and you can't really fix that. The other problem is that you basically just kick the can down the sidewalk for some next lawyer to deal with. And that doesn't serve the interest of resolving a case on its merits and seeking the truth. ultimately it's a client control issue. When your client comes in the door, one of the first things he needs to hear is you tell the truth no matter what. The case sinks or swims on the truth, we're not going to screw with it. And when he comes to trust you, he can realize that if he tells you all the truth, including the fact that you did rob the bank, you are better prepared to defend around it. And I've never regretted taking that position. I'd rather find out my guy robbed the bank from him than from a cross-examination in the middle of trial.
And let's look at some of the comments on remedial measures that the rule itself gives us. Again, I'm not sure, were the comments part of the handout?
Yes.
Okay, good. Oh, good. Let's look at remedial measures and just kind of read through some of that, because I think this addresses some of the quandary that this good colloquy of questions has helped us flesh out. So under remedial measures, comment 10, having offered material evidence in the belief that it was true, a lawyer may subsequently come to know the evidence is false, or a lawyer may be surprised when the lawyer's client or other witness called by the lawyer offers testimony the lawyer knows to be false, either during the lawyer's direct or in response to cross by the opposing lawyer. In such situations, where if the lawyer knows of the falsity of testimony elicited from the client during a deposition, the lawyer must take reasonable remedial measures. In such situations, the advocate's proper course is to remonstrate with the client confidentially, advise the client of the lawyer's duty of candor to the tribunal, and seek the client's cooperation with respect to the withdrawal or correction of the false statement or evidence. If that fails, the advocate must take further remedial action if withdrawal from the representation is not permitted or will not undo the effect of the false evidence. The advocate must make such disclosure to the tribunal and is reasonably necessary to remedy the situation, even if doing so requires the lawyer to reveal information that otherwise would be protected under client confidentiality. I mean, that's really tough medicine that the comment contemplates. Even in a situation where, like you said, Michael, you're forced to continue on. I mean, and at what point is the advocate then struggling with what obligations do I have to disclose to opposing counsel, perhaps things against my client's interests and or the court, to avoid getting the complaint from Dennis Carlson's office down the road by, whoever knows might say that I'm violating this canon of ethics. Look at 11. The disclosure of a client's false testimony can result in great consequences to the client, including not only a sense of betrayal, but the loss of the case and perhaps a prosecution for perjury. But the alternative is that the lawyer cooperate in deceit in the court, thereby subverting the truth-finding process which the adversary system is designed to implement. Let me give you then the Supreme Court case that really called upon, as I promised to do, the change in the rule. And you veterans probably are aware of Nix versus Whiteside. It was 475 U.S. 157, came down in 1986. The constitutional issue arose in the Supreme Court decision in Nix versus Whiteside. In that case, the Supreme Court, with no dissent, held that a lawyer's refusal to cooperate with a criminal defendant in presenting perjured testimony at trial does not violate the Sixth Amendment right to effective assistance of counsel. In Nix, the lawyer told the defendant, Whiteside, that if he, Whiteside, insisted on committing perjury, then it would be my duty to advise the court of what he, Whiteside, was doing, and that I felt he was committing perjury, also that I probably would be allowed to impeach that particular testimony. The lawyer also said that he would seek to withdraw from further representation. Whiteside, to buttress his self-defense claim in a murder charge, wanted to testify that he had seen something metallic in the victim's hand. However, until a week before trial, Whiteside had consistently stated he had not actually seen the victim with the gun. When asked about the change in testimony, Whiteside said, if I don't say I saw the gun, I'm dead. And so that actually caused, 1 year after Nix, ABA Formal Opinion 87-353 elaborated on Rule 3.3 and advised that the disclosure obligation of Rule 3.3 is strictly limited to a case where the lawyer knows that the client had committed perjury. The lawyer's suspicions are not enough. So it has to be actual knowledge. No means no. It does not mean no in an existential sense. K-N-O-W, yeah.
Can we jump back just a minute?
Oh, do. I just wanted to, I had to get off that Supreme Court opinion. Of course it is, or Sarah would have my job here, my boy. Go ahead.
but that's not what we're talking about. I wanted to agree with the observation because it strikes me that in criminal cases, the really big part is did you do it, what happens to you? And even though we often represent sophisticated clients who have been around the block, it doesn't necessarily mean that they understand the significance of what the truth might mean to them. I mean, all the time you'll have a client say, well, I was there, or this or that. And as a consequence, they don't understand that there are defenses, there are mitigation that you learn from getting the true facts that allow you to do a more effective job representing the client. So for purposes of answering the question of allowing a client to lie, you can't even make that decision if you don't talk to the client. And the client can't make a meaningful decision to pick the truth if you don't explain the context. So there are other rules that fit neatly over top of this question of allowing the client to lie. Back to where we are, my problem with the NICS rule, just so you know,
Sure.
is that your client, if you tell them the truth, I'm going to rat you out if you lie, is going to say, I never said that to you. I said something more amorphous or something less clear. And in truth, clients are forever changing their story to adjust to what you explain to them. Oh, let's talk about self-defense today. Yeah, I saw the gun. Let's talk about alibi, and I wasn't there.
No, I mean, and part of this exercise is just to, kind of getting us to focus on we have these rules that may make an academic or logical sense, but that's why I really value the input we have here. Then we have to apply them in the practical marketplace of representing defendants. Let me see if there's anything else on the criminal part of this, and then I want to make sure we transition a little bit into some of the civil, candor in civil litigation aspects. Okay, the lawyer, let's talk a little bit about the lawyer's obligation of candor in pretrial discovery. And looking to the comments. All right, so if a lawyer in a civil case discovers that her client has lied in a deposition, the lawyer must use all reasonable means to remedy the fraud, even though the lawyer may have acted completely innocently. For example, the lawyer should first remonstrate with the client. If that fails, the lawyer must take other measures, including revealing the perjury to the judge. And that's, again, the comment interpreting the rule. And also speaks to extending the obligations of candor outside the courtroom. And that part of the rule that says it's all the proceedings leading up to the courtroom that you have the obligation of candor and disclosure to the court, which takes me, I promised, a second Nebraska case. This one where you have, in the first one I cited you to, you have the lawyer representing himself. Here you have the lawyer initially in a proceeding outside the courtroom, but taken into the courtroom as far as misrepresenting really a legal posturing of the case. And let me get to that Supreme Court opinion. Give you your second Nebraska decision to take. This would be State versus William Paul Bouda II, B-O-U-D-A II. A decision reached August 21 of 2009. And the Supreme Court found 270, Nebraska 380. And give you the facts. The substance of the referee's findings, the referee leading to this action before the court, may be summarized as follows. The respondent was involved in the private practice of law from 1990 until 2007, with the dominant focus of his practice being insurance defense litigation for AAA, Motor Club. As of August in 2007, the respondent left the private sector and entered employment at Catholic Mutual Group. That's there. He
arrangements to turn over his AAA defense files to an attorney with the Fitzgerald Shore firm in Omaha. However, he retained 3 files, including rear-end collisions he believed had warranted and were ready to settle. He'd handle himself. In one of those files, the respondent retained, he was defending AAA against a Ms. Tucker in suit filed by Olson in the District Court of Douglas County. At his hearing, the respondent testified that he had received notice of the case involving Tucker was set for trial in April 2008. The respondent stated he had decided that the case should be settled because Tucker would not make a good witness, the defendant, and didn't have a valid defense. The problem is, the respondent admitted that he did not try to contact Tucker at the trial. As the trial was approaching, the respondent claimed he did send emails to counsel, but he couldn't produce those emails and said they must have been a computer virus on the way. He didn't have the emails showing he had told counsel these facts. The respondent's testimony in the referee's hearing showed that the respondent was not prepared to go to trial. He did not have the authority to settle the case. Nevertheless, on April 7, 2008, he represented to both opposing counsel and the district court that he had authority to settle, and that after April 7th, he had inaccurately represented that he had both authority and had disclosed to his client that he wanted to settle the case. I cite this because I think anyone who has practiced in this area probably recognizes, especially if you have, a quiver of 55, 60 defense files going on at one time, or conversely, plaintiff's files and accident cases going on at one time, how easy it might be. He initially gets into trouble, and he's found to have misrepresented factually that he had the authority to settle, which is really a factual thing, and that his client wouldn't make a good witness. Well, that's kind of a combination, mixed question of law and fact, wouldn't you agree, Mike? And his problem was, however this came out, as far as the referee's finding against him, Mr. Good had not contacted the defendant himself. So he had no idea of whether he made a good witness, and had not sought, and could not establish that the insurance company, on an old retained file in maybe a throwaway case, I think it was like a $10,000 settlement, next to nothing. But, a 6-month suspension for the practice of law. So the point of it is it does carry over into the civil practice area, and it does apply as far as the misrepresentations of fact to situations outside the courtroom, because it's clear that even though at some point in time he did have the Douglas County District Court hearing where he made, again, factually incorrect representations to the court as to why we don't plan to go to trial because I'm going to settle the case, I have authority. All the evidence really was all about what he told opposing counsel and what he represented outside the courtroom to opposing counsel. And I'm not sure, frankly, of how the thing gets sent to Dennis Carlson's office, but it got there, and it got him suspension from the practice of law. Yes, ma'am.
What was the case number on that?
It's found at 770 Northwest 2nd, 648, and at 278 Nebraska 380. Is that what you're asking? Okay, good. I'm just so out of practice doing citations because I had no law clerks this week, and so I had to do my own research. Thank you for making me respond accordingly. Okay, before we break, I want to talk about one other element of the rule as it applies to the civil context, not just the criminal elements of it, remedial measures, duration of obligation. Okay, so we talked about disclosure of that false testimony. Let me go back and read, I think, comment 12 as far as preserving the integrity of the adjudicative process. Lawyers have a special obligation to protect the tribunal against criminal or fraudulent conduct
that undermines the integrity of the adjudicative process, such as bribing, intimidating, or otherwise unlawfully communicating with a witness, juror, court official, or others participating in the proceeding, unlawfully destroying or concealing documents or other evidence, or failing to disclose information to the tribunal when required by law to do so. Paragraph B requires a lawyer to take reasonable remedial measures, including disclosure if necessary, whenever the lawyer knows a person, including the lawyer's client, intends to engage in or is engaging or has engaged in criminal or fraudulent conduct relating to the proceeding. So if there's also the affirmative obligations if you have something the client reveals that actually may precipitate a criminal act going forward. I'm reminded of Irving Stone's biography of Clarence Darrow, and I don't know if you guys recall, some of you may recall the Henry Fonda one-person Darrow presentation. One of my favorite stories that Darrow was narrating from practice in Chicago. He would talk about, in my early days of practice, it wasn't unusual, to have a client come in with limited resources. I recall, taking fees in produce and promises for future payment and almost every sundry type of thing, and rarely did I turn someone down. There was just a problem. There was this one case, he said, however, where a fellow came into my office and said he'd been accused of bank robbery, and what would require to retain me, and I decided that I would need a $500 retainer, and the fellow said, well, I don't have it now, Mr. Darrow, but if you give me a couple hours, I think I could raise it. And he said, I turned down that fellow and said he might want to suggest other counsel, and then in Henry Fonda style, he turned to the audience and he said, I never, ever recall accepting a retainer in the form of money I believed had been stolen so recently. That's one of those wonderful pause for effect. So I'm not suggesting that any of the brethren among you have ever accepted, how are you, Suzanne? Situations involving fees that historically may not have been, but that rule is probably some sort of admonition that makes sure it doesn't happen too recently. Then finally, on the comments, the duration of the obligation, I think is important. I mean, how long do you hold a judge to this duty of candor to the courtroom, whether it be in fact or law? A practical time limit on the obligation to testify or rectify false evidence or false statements of law, in fact, has to be established. The conclusion of the proceeding is a reasonably definite point for termination of the obligation. A proceeding has concluded within the meaning of this rule when a final judgment of the proceeding has been affirmed on appeal or the time for review is passed. So if you're sitting on that sort of time bomb and you're wondering, can I still be called to testify, or can I still be asked to disclose, at least when there comes a point in time when the case is settled and done, where you're off the hook as former counsel. All right, so that is primarily my comments on, as to the extent we have anything prepared ahead of time, on 3.3. Other questions before we break, and then we'll talk about 3.4 and 3.5 after.
I do have a question. The caption for 3.3.3 is duty of candor for the tribunal, but I wonder whether or not, because when you get to talking about duty of fairness, opposing counsel, and those kind of things, the standard seems to be a little different. Is it your sense that the duty of candor also extends to opposing counsel, to opposing parties? And I bring it up because of last year's decision by the Nebraska Supreme Court in a disciplinary case involving, remember that case? A lawyer who represented somebody in a horrendous traffic accident, and negotiating with the State Department of Health and Human Services said, we'll give you back dollar for dollar if you'll pay the medical bills. And then after the medical bills were paid, the settlement came in, and they didn't pay back dollar for dollar. Instead, there was a lawsuit filed saying, we don't have to pay back dollar for dollar. You should negotiate some proportionate recovery. The Nebraska Supreme Court was really quite critical of that negotiating thing, and apparently referred to now Mark Weber's office, Dennis Carlson's office. Well, so my question is, doesn't the duty of candor really extend beyond not misleading the judge to not lying to opposing counsel?
Well, yeah, and we're going to talk a little bit about that after the break too, Michael. But I think you're right. I think the rules have a distinction, and as far as practical application, there's a distinction because as far as opposing counsel, for example, we'll talk about trying to hide evidence or disclosing evidence of discovery to opposing counsel, as opposed to your duties of affirmatively advising, for example, the court as to contrary authority. I think, number one, advising opposing counsel to contrary authority is not really as much a concern as the court being advised of authority against your position. In an ex parte proceeding, for example, there's a special recognition of the rules that if you're going before court on a TRO before the temporary injunction hearing, on that routine motion where you don't have any opposing counsel, there's almost a special obligation the code calls for on being completely candid with the judge, including letting her know of contrary authority to your position. So when you're there without opposing counsel in the room, there's even, I think, a special obligation of candor on both questions of fact and especially questions of law. When you know there's authority against you out there, or yet you're frankly misrepresenting to the court the import of a decision or statute, that can land you into a complaint before counsel. Other questions before the break? Okay, so let's come back at 5 after, and we'll pick up. Is that about 10 minutes from now? Okay. Okay. Let's go back on the record, as they say. Are we back on, Sarah? All right. Okay, now we're going to talk about, for the next 25, 30 minutes or so, Rule 3.50, 3.4, fairness to opposing party and counsel. And let's just kind of begin and look at the black letter law.
But before you go there,
Go ahead.
let's just make it crystal clear. This does not apply to criminal defense lawyers and opposing counsel lawyers. We never have to tell prosecutors.
Well.
We never have to be honest or.
Michael, why don't we do it this way? Let's kind of work through point by point, and I'm going to let a prosecutor like Mr. Austria tell me when criminal lawyers are off the hook. And then if there's a fight between the two of you, I'll let hell be arbitrated, okay? All right. A lawyer shall not, A, unlawfully obstruct another party's access to evidence, alter, destroy, or conceal a document or other material having potential evidentiary value. A lawyer shall not counsel or assist another person to do such act. I think that's kind of self-explanatory. After all, apart from first-year law school, I don't think we've done that to opposing counsel, have we? That one seems clear. B, falsify evidence, counsel, or assist a witness to testify falsely or offer an inducement to a witness that is prohibited by law. C, knowingly disobey an obligation under the rules of the tribunal except for an open refusal based on an assertion that no valid obligation exists. D, in pretrial procedure, make a frivolous discovery request or fail to make reasonably diligent efforts to comply with legally proper discovery requested by opposing party. We're all smiling there and looking for the interpretation. C, in trial, allude to any matter that the lawyer does not reasonably believe is relevant or that will not be supported by admissible evidence, assert personal knowledge of facts in issue except when testifying as a witness, or state a personal opinion as to the justice of the cause, the credibility of witness, the culpability of a civil litigant, or the guilt or innocence of an accused. And let's make sure we talk about the sort of rules, the comments, in terms of both opening statement and closing argument when it comes to interpreting that canon. F, request a person other than a client to refrain from voluntarily giving relevant information to another party. And that's going to be an interesting one we'll talk about with the comments, unless, under F, that person is a relative or an employee or other agent of a client, and two, the lawyer reasonably believes that the person's interest will not be adversely affected by refraining from giving such information. There's a real careful cautionary note to your behavior to third-party witnesses having information germane to the controversy that we'll talk about in the comment. Okay, I'm not going to spend a lot of time on the comment under just deliberately destroying, altering, or concealing the document. I recall, Kathleen, there is an old Supreme Court case out there where the lawyer tampers with, going back about 80, 90 years ago, with a piece of evidence and is caught. It's caught by a post counsel. So there is some Nebraska case authority. Suffice it to say, I think it's pretty clear, the rule talking about the integrity of the evidence, the integrity of the process as far as physically tampering with evidence. Under the comments, documents and other items of evidence often essential to establish a claim or defense. Subject to evidentiary privileges, the right of an opposing party, including the government, to obtain evidence through discovery or subpoena is an important procedural right. The exercise of the right can be frustrated if relevant material is altered, concealed, or destroyed. Applicable law in many jurisdictions makes it offense to destroy material for purposes of impairing the availability in a proceeding. Paragraph A applies to evidentiary material generally, including computerized information. Applicable law may permit a lawyer to take temporary possession of physical evidence of a client crimes for purposes of conducting a limited examination that will not alter or destroy material characteristics of the evidence. Okay. With regard to paragraph B, it is not improper to pay a witness's expenses or to compensate an expert witness on items permitted by law.
The common law rule in most jurisdictions is that it's improper to pay an occurrence witness any fee for testifying, and it's improper to pay an expert witness a contingency fee. So I mean, that's a lesson to all of us who have used experts and why we counsel our clients that the payment of the expert witness is not contingent upon a case result, and that would clearly be a violation of this canon. Paying for factual testimony by witnesses would probably conjure up problems beyond this particular rule as far as what the common contemplates. All right, and then reading, and now I'll go back to, I think, some of the things that Mike pointed out. The ethic rules imposed on lawyers certain affirmative obligations of candor to a tribunal, for example, to disclose material adverse authority. However, with respect to opposing parties or third parties, the lawyer's duty in general is more limited. I think that was your point earlier, Michael, that the rule of our candor to the judge, to the courtroom process itself, is a higher standard or a different standard or a more elevated obligation than the rules, obligations of candor toward opposing counsel. Subject to various exceptions, the fundamental principle of ethics is that lawyers must not knowingly misrepresent either a material fact or law to opposing parties or other persons. This principle applies whether the lawyer is involved in litigation or negotiation. And so one of the points made throughout is this isn't just, even though our title is Candor in the Court today, it's not limited to just the courtroom, the four corners of the court itself. For example, Rule 4.1a states that in the course of representing a client, the lawyer, quote, shall not knowingly make a false statement of material fact or law to a third person. Rule 8 provides that a lawyer engages in professional misconduct when he or she engages in conduct involving dishonesty, fraud, deceit, or misrepresentation. And then there is 3.4, which is the subject of this section, that talks about the fairness to the opposing parties. So some of it can be elevated to violate more canons than just the canons that we're discussing here. Let me talk about,
as I alluded to, the limitations beginning on how you can give your own opinion and impression of the evidence in an opening statement or a closing argument, and when you cross the line. Because I think there it becomes a little bit more of a subjective area in terms of what you as the advocate for your client's interests may say to a jury in particular, is I think what provokes the objection as opposed to judge-tried cases, on your own personal opinion of the evidence, of the question of guilt or innocence, of you always maintaining, suffice it to say, I think the objectivity of the lawyer and not blurring the line between you as the advocate and the lawyer as some sort of a factual witness to events. So the ABA rules provide that during the trial, the lawyer may not allude to any matter not reasonably believed to be irrelevant or admissible. And then they go on to say, during the trial, the lawyer may not, in closing argument or otherwise, assert his or her personal opinion or knowledge regarding facts at issue, unless he is actually testifying as a witness, himself or herself. However, the lawyer may argue for any position or conclusion based upon his analysis or her analysis of the evidence. Consider two examples that illustrate this principle. First, assume that in closing argument, the lawyer states, quote, how can you believe this witness? Question mark. I've seen many people testify over the years, and in my experience, this witness is lying. I don't believe him. Can you, close quote. The lawyer's action, according to the ABA comment here, is improper even if the lawyer really believes that the witness is lying, because the lawyer may not assert his personal opinion regarding facts at issue. That's the comment. Now, assume that in closing, the lawyer states this, quote, how can you believe witness? His testimony contradicts the sworn testimony of three other people who, unlike witness one,
have no financial interest in this case, close quote. This example of the lawyer's closing is proper because he is trying or arguing from the evidence that is a matter of record presented to the court. So you see the distinction there? You take you, if you will, you the lawyer, out of the equation as someone testifying or giving a factual reaction to credibility. And you react in a sort of a subjective third-party way to saying, you know, witness A could not be telling the truth because we have 3, 4, and 5 witnesses who testified to the opposite fact. Is this a meaningful distinction? The comment asks. Why does the law permit one form of argument, not the other? We must realize that whenever the law offers a bright line rule, it may appear arbitrary that one will violate the law by being outside the line and follow the law by being inside the law. That is the price we pay for precision. In this case, the bright line is not difficult to justify. The law does not want lawyers purporting to be witnesses, vouching for their client's veracity, yet lawyers can argue from the evidence, and that argument can be colorful, whether by metaphor or simile. All right, so there you have it. Does anyone have any personal examples of that situation in closing, either where you've objected to someone inserting himself or herself into the adversary process? Yes, sir.
I've got one. I tried a wrongful death med mal case 7, 8 years ago. The other attorney in closing argument on some issue, I don't recall what it was, tossed in a comment. He said, I think, whatever it was. It was just his own opinion about something that might have happened that there was no evidence of. He just kind of tossed it out. You're a highly experienced, capable attorney. I think it was just kind of an instinctive thing. He wasn't intending to break any rules.
Jury trial context?
Jury trial. I made one of those kind of snap decisions to just let it go by. Could have raised all kinds of hell over it, but I didn't. When the jury ruled against us, and I talked to the jurors, that was the one thing that stood out in their mind. So, you know, those things matter.
Lesson learned.
Yeah.
Wow, yeah, lesson learned. Anyone else to comment on experience or the rule itself? Okay.
Mr. Helmy told me this, that today the Nebraska Supreme Court has spoken about it. I haven't seen the opinion. Isn't that right?
On something like this one, the lawyer in closing?
Prosecutor made an argument during closing to the effect that there was no evidence to prove a particular fact. In fact, that prosecutor knew that there was no evidence presented at the trial. There was evidence available in his reports to reflect that. The court found that constituted prosecutorial misconduct in which the case was not objected to the trial. Court of Appeals.
Court of Appeals, and without trial objection, Scott. That's interesting.
Was that comment made in closing or opening?
In closing.
So was there evidence? You said there was evidence in the reports, but was there evidence in the
Evidence of the trial, there was no evidence of the trial to point to the attorney's comment on it. The attorney made the comment broad enough that it was perceived that he was saying there was no evidence at all. The attorney did not comment to there was no evidence presented during testimony at this trial. In fact, said there was no evidence to support it. It was in fact evidence to support it.
And it was pertinent to the jury deliberations too. They came back with a question asking about the prosecutor saying that there's no police report to support this. And so it was obviously pertinent to their deliberations.
Oh, sure. Well, that takes it right out of harmless air. Real quick. Yeah. Well, yeah, good point. I mean, you can't get a better example of, let's see, now, Mike, I come full circle. You say that this really doesn't have anything to do with us criminal lawyers. Yet we have.
Well, but prosecutors aren't criminal lawyers.
That's right. There you go. Prosecutors are the difference between us and an uncivilized society. Public servants in the finest sense of the term. Wouldn't that be it, Mr. Austria? There it is. Okay. All right. Other
other comments on this point of the rule as far as the candor to opposing counsel? I think another interesting one that we as just trial practitioners from time to time can come around is note where we read about the rule's admonition toward contact with third-party witnesses. And I think it's good to reflect on that. And again, this probably speaks more to civil trials, but also to criminal trials also. A lawyer may not obstruct her opponent's ability to collect evidence. However, she may advise her client that he should not volunteer any information to the opponent. No problem with telling, of course, your client's representatives, you don't have to talk to anybody, you don't have to volunteer anything, that we can control. Then the only way for the other side to secure information would be subpoena, deposition of the lawyer's client. In those circumstances, the lawyer will be able to protect the client's interests by reviewing documents before they're turned over, etc. There are certain types of non-clients whom lawyers can request not to volunteer information. The general rule is that on behalf of his client, the lawyer may always request an unrepresented non-client witness to refrain from voluntarily giving relevant information to another party if the witness is the client's relative, employee, or agent whose interests will not be adversely altered if this request is honored. And understand that request. You don't have to volunteer anything. You can wait to be properly subpoenaed. The lawyer, however, cannot forbid such witnesses from being interviewed. Whether they are in fact interviewed is up to them. They can always insist on being subpoenaed and then deposed. The lawyer is merely informing them that they need not volunteer and can require the other lawyer to subpoena them. However, again, this is the ABA comment on the rule. Lawyers have no right to request other non-clients, i.e. witnesses with no connection to the client, to refrain from volunteering information to the opposing lawyer. For example, in North Carolina State Bar versus Graves, that's a North Carolina case found at 274 Southeast 2nd, 396 in the year 1981. The court upheld the discipline of an attorney who attempted to influence a witness who was not his client to refuse to testify or alternatively to plead the Fifth. Although the witness had a constitutional right to plead the Fifth Amendment, it is still a criminal act, emphasize criminal act in this comment, for someone, quote, with corrupt motive to induce a witness to exercise that privilege, close quote. To exercise the privilege, close quote. People versus Keneally offers another interesting example. In that case, the court suspended an attorney because he drew a contract under which the client settled a civil case against a party and in exchange agreed to evade a subpoena in that party's upcoming criminal trial. That is found at 607 Pacific 2nd, 1078, a 1980 case. All right, so I thought those were some good examples to sort of flesh out that other part of the rule that talked about third-party witnesses and your ability to coach, advise, control, conceal, or otherwise interfere with those other than your client. Any questions, comments, or experience from the assembled in the room on that issue of interesting problems with third-party witnesses? Okay. Let me see if there's anything else in my notes under, oh, I thought this interesting from the comments. This comes up in, I go back to my criminal trial brethren here. How am I doing on time? Okay, we're okay, yeah. Yes, before you went to part 3. Misleading the court as to the identity of the individual sitting at counsel's table. we all can harken into that, can you point out, the defendant and the old trick of putting the wrong person at counsel table in the defendant's seat. Is that allowed under 3.4b?
eyewitness identification is one of the most persuasive types of evidence. Not necessarily the most reliable, as we've learned through the Innocence Project, but certainly with juries the most persuasive. But it is often wrong, as shown by a blitz of overturned jury verdicts based on eyewitness testimony and DNA testing. Consequently, some lawyers have sought to conduct their own in-court lineups by having someone who is not their client sit at counsel table and pretend to be the accused. Courts have held lawyers in contempt for that tactic on the grounds that it violates court custom or the rules of the tribunal governing who may sit at counsel table and misleads the court. Citations under that include United States versus Thureen, found at 653 Fed 2nd 1332, a Ninth Circuit decision in 1981. Other courts do not appear to be concerned with this tactic. In light of the divergence of authority, the careful lawyer who wishes to engage in such contact should tell the judge first. How about that? Yeah. Well, but, and it makes some sense, for goodness sake, if you're going to try that.
Well, then your witness is kept up. Then the other guy's witness is kept up.
Okay. Anybody with experience on this? Yes. Yeah.
Can I have you repeat people's questions?
Oh, thank you. Thank you. Ann, what was your question?
Well, if you tell the judge you're not going to do it, then you probably line up and see if the witness really can identify him. You can criminally charge a client. You're obviously also going to be advising opposing counsel.
Right.
You assume he's going to profit out of it.
Your point being no ex parte contact with the judge.
Well, no. My point being, then the jig is out.
Right.
If the prosecutor knows that the witness is.
Well, but the suggestion here is I think, clear it with the court, and then let the judge tell you if you have to then disclose that to opposing counsel or whether he or she.
I don't think you can do that. I don't think you could just go to the judge and go, hey, what do you think about this tactic?
Anybody have experience with the tactic?
I've never tried that. I've thought of it for the obvious reason. And I guess my thinking was, and there seems to be a split of authority on it, if you can do it without making any misrepresentations to the court, you ought to be safe as long as your client is in the courtroom. And the arguments against it, I think, fly in the face of reality. And again, I've never done it. But the point is that the person sitting next to you at counsel table is so strongly assumed to be the defendant that the witnesses just get flippant and stupid and they'll say, yeah, that's the guy. That's a huge tendency. And being unable to undermine that in a way deprives your client of his right to counsel or his right to trial or something. Because it's way more effective than cross-examination. So it seems to me it should be available.
The problem with that strategy is by putting an imposter in the defendant's chair, you're in effect vouching for the identity of that as the first accused. It would be a different, still highly questionable strategy to leave the chair vacant and have the defendant sitting in the gallery.
Or have 5 guys sitting behind you.
Yeah.
The problem often enough is your guy in an orange jumpsuit with the 2 sheriffs. Not any.
Yeah.
These are like possible test questions.
Yeah.
Real world.
But I think you mislead in a factually, knowingly way, putting a false person in that chair.
But the flip side of the coin is having your defendant in the chair basically advises a witness of something he might not otherwise know. And you don't have to do that. But I think your solution is a good one.
I think, don't misunderstand. I'm not advocating you put the defendant in the back of the room. I don't. I think you can go ex parte to the trial judge and say, in this case, identification is a legitimate issue, and therefore I want your permission for the defendant to be in the courtroom but not to sit next to me. And I don't think the judge is required to disclose that if you can persuade the judge that there's a legitimate factual issue surrounding identification.
How do you do that? How do you approach this?
Well- Let me give you the citation, Ann, to where should tell the judge first, is at footnote 10, the Thureen court suggested that counsel could first seek the court's permission to
1, have more than one person seated at counsel table without identifying which one is the witness or defendant, or 2, have no one seated at counsel's table, or 3, have the in-court lineup. That's found at 653 Fed 2nd at 1342, 653 Fed 2nd 1342, and the case is,
I assume that case doesn't say.
Thureen.
Ex parte, it just says.
Right, no,
First ask
you're correct, right. It does not say that. That's the Thureen case, and 653 Fed 2nd 1332, a Ninth Circuit decision in 1981. And again, in the ABA comments to these rules is where you get these examples. But that's exactly what you suggested, Mike. As far as that's a very different proposition, the empty chair or more than one, than the defendant's chair next to counsel being an imposter. I think that's
your obligation of being candid with the tribunal, 3.3, comment 14 specifically addresses the reality of the occasional ex parte contact. And we all know that prosecutors go to the judge routinely with an affidavit for a search warrant, even though they're going to search my client's house and they can invite me to come and be there because there's 3 other pending charges or for whatever reason. And yet those ex parte contacts are not questionable or unethical. And I suspect it's a complicated question, but the thing you can't do is overtly lie, and putting a ringer in the defendant's chair is that.
And that's why I gave the cases to suggest that even in the federal example, the Thureen case, where it was discussed and the tactic was employed in some respect, they talked about the solution of possibly having the in-court lineup of multiple people, the empty chair, or again, more than one person, not a person sitting in deliberately misleading the defendant at trial. Okay, let's go to the final one now in our last 25 minutes here. The 3.50, 3.5, the impartiality and decorum of the tribunal itself. What should a lawyer not do? 1, seek to influence a judge, juror, prospective juror, or other official by means prohibited by law. 2, communicate ex parte with such a person during the proceeding unless authorized to do so by law or court order. Or 3, communicate with the juror or prospective juror after discharge of the jury if, under I, the communication is prohibited by law or court order. 2, the juror has made known to the lawyer a desire not to communicate, or 3, the communication involves misrepresentation, coercion, duress, or harassment, or 4, engage in conduct intended to disrupt a tribunal. And under that is B, a lawyer shall reveal promptly to the court improper conduct by a venire person or a juror or by another toward a venire person or juror or a member of his or her family of which the lawyer has knowledge. So there is an affirmative obligation placed upon the advocate, the courtroom lawyer, to disclose, to report violations of the rule witnessed by that attorney. Under the comments then, because it's a fairly short section, so I'm just going to go ahead and note the comments. An obvious point, many forms of improper influence upon a tribunal are prescribed by criminal law. Then 2, during a proceeding, a lawyer may not communicate ex parte with persons serving in an official capacity in the proceeding. No ex parte communication with judges, masters, or jurors unless authorized to have that ex parte communication by law or court order. The 3rd comment under this rule, a lawyer may on occasion want to communicate with a juror or prospective juror after the jury has been discharged. The lawyer may do so unless the communication is prohibited by law or court order, but must respect the desire of the juror not to talk with the lawyer. The lawyer may not engage in improper conduct during the communication.
4, the advocate's function is to present evidence and arguments so that the cause may be decided according to law. Refraining from abusive or obstreperous conduct is a corollary of the advocate's right to speak on behalf of litigants. A lawyer may stand firm against abuse by a judge, but should avoid reciprocation. The judge's default is no justification for similar dereliction by an advocate. So even an outrageous judge doesn't give you a blanket immunity to retaliate. You always have to worry about retaliation. An advocate can present the cause, protect the record for subsequent review, and preserve professional integrity by patient firmness no less effectively than by belligerence or theatrics. And then the 5th, the duty to refrain from disruptive conduct applies to any proceeding of a tribunal, including the deposition. So once again, I think like all of the 3 tenets we've talked about today, it extends beyond the courtroom into the discovery, the deposition process, or the ancillary proceedings that relate to the trial itself. Okay, with that in mind, I wanted to go to some of the ethical comment in the ABA guide as far as 3.5. And the first part of it just kind of defines broadly what the rule is intended to address. 3.5 makes a lawyer subject to discipline for engaging in conduct that already is illegal in many ways. The purpose of the rule is to make clear that a lawyer who engages in such conduct must fear not only the sanctions, such as private to jury and the criminal prosecution, but the threat to his or her license to practice. On comments on disrupting the tribunal, that's always an interesting notion. What constitutes a disruption? The lawyer may disobey a tribunal's order if there is an, quote, open refusal based on an assertion that no valid obligation exists. That is the lawful way to disagree with the judge. The ethics rules forbid unlawful ways to disobey a court order, and thus they explicitly forbid disrupting the tribunal. Thus, the court in the decision in the matter of McKelvey severely reprimanded the attorney who, at a sidebar conference, threatened, parenthetical and vulgar terms, close parent, physical violence to the Deputy Attorney General. This lawyer also later attacked the Deputy Attorney General during a conference in the judge's chambers when the judge and his law clerk tried to separate the two men. Well, of course, they would note that they're men here. Yeah. And now locked in combat, they were drawn into the fight, and at one point all 4 were rolling on the floor. Just as the lawyer official may not accept anything, of value offered to influence his or her actions as a public official, neither may the lawyer seek to influence a public official or juror improperly. I should cite that one example. Let me give the case cite to that. Yeah, the matter of McKelvey is found at 69, wouldn't you know, New Jersey. Sorry, Governor Christie. 349, 354 Atlantic 2nd, 289, a 1976 case. My gosh, that's an old quarrel. Just as the lawyer official may not accept anything of value offered to influence his or her actions as a public official, neither may a lawyer seek to influence a public official or juror improperly. A lawyer may not use his public position in order to gain a corrupt advantage for himself or his client. The basic question is whether the effort to influence the tribunal was corrupt. Consider, for example, a lawyer legislator who appears before the State Commerce Commission to urge a rate increase on behalf of a private client. Now, this lawyer legislator is also on the State House committee that oversees the State Commerce Commission and sets the administrator's salary. Such circumstantial facts alone do not show anything improper, but the lawyer legislator must also have actually engaged in an overt attempt to exert improper influence over the State Commerce Commission. And that example came out of State ex rel Nebraska State Bar Association versus Holscher, found at 193 Nebraska 729 230 Northwest 2nd, 75, 1975. So it's not as that example illustrates, what appeared to be a conflict situation still requires the overt act of the lawyer legislature to step over the line and to corrupt the process. Ex parte communications during the proceeding, you recall the rule talks about not conversations with judge, magistrate, juror. As part of the ground rules of litigation, lawyers are prohibited from contacting, quote, persons acting in an official capacity in the proceedings, such as judges, masters, or jurors, unless permitted by law or court order. This provision and other court rules delineate what judges and court personnel may do with respect to ex parte conduct. As one can imagine, courts and parties need to communicate about scheduling and other administrative matters. However, ex parte communications that address merits of a matter undermine the public confidence. When all parties are not present to hear a communication with the court, the litigants cannot voice their positions or preserve their rights on appeal. Of course, there may be exceptional circumstances where ex parte conduct is permitted by law or court order. So obviously, you need to delineate out ministerial things, scheduling things, that innocuous type of conversation you have with the court officials. And then I think as we all have told jurors, from the moment in time, they are finally chosen and impaneled to hear the case, it's just, beyond, well, my personal preference is not to say anything, but I've certainly witnessed, I'm sure we all have, and respect when opposing counsel say, please do not consider it an effrontery or rudeness on my part if I, pass you in the hallway and just avoid even saying good morning, or don't acknowledge you're saying good afternoon to me, because I just, as the judge has told you, can have no discourse whatsoever with you between now that you have been chosen to act as a juror until such time as you've been discharged. And I do want to talk about that because we've all been interested in that process about after the jury is discharged, those of us who are interested in finding out what his or her decision was based upon, that led to that happy or disappointing result of the verdict, and what the rules say about that. Okay, speaking of that, 5.4, communicating with the jurors after discharge of the jury by the court. And what's interesting, I'm sure many of you have had the same experience as I. You have the judge. I'm not going to remember the names of the judges because, well, in the first place, I wouldn't tell you if I did remember. The second place, since I'm 64, I don't remember what happened last week. But there are the judges who tell the jurors, members of the jury understand that counsel may contact you after you're discharged, and you're free to visit with counsel if you want to. And you're also, and I've seen different judges kind of be proactive. You don't have to tell Mr. Gooch anything. You could just refuse to talk to him, and that's entirely up to you. If you want to visit with anybody about the reasons for your decision, your deliberations, or anything. And many times judges say nothing. Other judges are much more proactive in how they counsel the juror. But let's talk about just briefly here. Yeah, yeah, Eric.
And we come back to we need to. Ann and I practice on tribunal where there's at least one judge who you may have a motion hearing or something of that nature. They make an attempt to have it be a call with both sides on the line, but inevitably, if more than one party is present, that judge may say, "Well, tell me what's going on in this case." And so
I think that's a little bit beyond schedule. Yeah,
it is.
Yeah.
And so, I try my best. I do not routinely say, "Judge, I can't talk to you." Not sure that judge will get somebody's paralegal on the line or something sometimes. Sometimes just you and the judge. So, does anybody routinely hang up on the judge or say?
I say, let me get Eric on the line, or let me back off and see if I can find Eric for you. We'll call you back. I do, I try to make those attempts
Yeah.
also. Yeah, and if I just have to listen, I try not to give information. You know, that happens. I try not to give information yet. If it happens, then I have to call you and say, what just happened?
And you know what could be really helpful to,
Oh, okay. Thank you. Thank you. Again, for those of you who are on the line, or how are they, whatever. You know who you are out there at Alliance in Scottsbluff. The question was, what do you do as an advocate in those situations where, and we've all had it, you have the friendly judge, the kind of more casual member of the court, of the judiciary, the decision maker, the arbitrator who says to, like in Eric Brown's example, just give me an idea what's going on in this case, you know, having that sort of conversation. Well, it's obviously something beyond scheduling. Well, you know, Judge, we're going to hear that matter next week, and then how do you sort of deflect that so you don't talk about the merits in an ex parte communication with the decision maker? And the point Ann made in response, I think, is a good one. As best you can, you know, without alienating that particular judge, you say, why don't I get a hold of Eric, and maybe we can come by and talk about it, or maybe even schedule a telephone conference. Hint, hint. But it does happen. You know, one of the best things I have found that comes to mind that a lot of judges use very proactively is their bailiff. And so often, you know, the bailiff gets on the line on some sort of a motion matter that has to be reset, or some sort of rescheduling, or anything that would necessitate conversation, and he or she that has the back and forth, or has the, you know, I'm not concerned about having ex parte contact and even discussing what the issue that we're going to argue with the bailiff, because they're skilled to understand that's an ex parte communication, as opposed to that conversation with the judge. Now, you're shaking your head. And
I'm not really shaking my head, but I'm saying there's probably a broad difference in practice.
Yeah.
Probably pretty good here. What you're in effect doing is having a back and forth with the judge on the merits through the judge's agent.
Mhm.
That is probably a problem for the judge.
Mhm. Yeah. No, I can. It can be tricky. It can be tricky. Thank you for those examples. Let me touch upon, before we dismiss everyone here, you're going to give me that 5-minute sign. Communicating with the jurors after discharge, because I think all of us have been interested in or had the process of wanting to have that conversation. So this talks a little bit about the history of the model rule. It was not unethical originally for a lawyer to question jurors after they were discharged, as long as the lawyer did not harass, induce, or embarrass the juror. In 2002 revisions, the rule stated that during a lawyer may not communicate ex parte with the juror during the proceedings unless authorized to do so. Then it was interpreted to prohibit lawyers from communicating with jurors after they were discharged. Then we had some revisions beyond that. Then, okay. In 1996, a federal district court held that the Hawaiian version of the rule was unconstitutional as applies to post-verdict contact with jurors. The case involved a pro se plaintiff who was also a lawyer, therefore covered by the rules. He asked the defendant in the court if the jurors could stay behind after the verdict so that they could ask jurors questions. And he was sanctioned for that, and they changed that to where that was allowed. The new Rule 3.5 will raise other issues for the process. The rules create a duty that all lawyers stay and interview jurors to determine if a basis for appeal exists. You can have that sort of contact back and forth. Will such new information cause the standard of review on no impeachment to be changed? Okay. So what they're basically talking about in the comments is, I think, to what extent you must be allowed to have access to have interaction with the jurors to simply conduct discovery as to whether or not did something improper or unethical take place during deliberations. You know,
did like in the notorious silence case in Nebraska, did the sheriff that was supposed to be babysitting the jurors, have contact with jurors during deliberation. It caused a new trial for Erwin Charles Simons. Some cases that some of us with greater beards can recall. You have to be allowed, under any state's rules of conduct, some ability to actually conduct legitimate discovery of what transacted in the jury room. And so that's the concern for those states who tried to restrict jury access to lawyers after the case was concluded. Then, what I found, then just as a practical matter for that more just academic contact with jurors in Nebraska, is that you have, from my experience, well, two things I've done in the last 10, 12 years. I don't try to avoid contacting the juror myself. If I want objective reaction to sort of a review of my own performance, if I have someone in my office, a legal assistant, a law clerk, make the contact on behalf of Bob Bartle, and we're just trying to, examine how we conduct the trial, or just try to get information on how we can better present evidence the next time, would you be willing to talk to me? And it's, Sarah Jones or Joe Smith making the call instead of me, then the juror is perhaps more inclined to give objective information to you than he or she would be otherwise. But who knows? About half of them will talk to you, from my experience. About half of them say, no, I really don't want to talk about it. Civil cases, by and large, I think are easier to conduct the back and forth than I'm told criminal cases are. I'm told by prosecutors and defense attorneys in criminal trials that they're a little bit more reluctant. Especially, for example, in high-profile cases with dire consequences, to talk. Some of you who tried those big cases, Scott, have you tried to talk to jurors and get feedback after a murder case?
When you compare it to civil cases,
Okay.
I would say that it varies jury to jury and person to person.
Yeah. Do you call them yourself, or do you ask somebody in the office? Yep. And do you concur with my impression that they're more candid in the feedback to? Yeah. Mike, any?
There's no way to do a controlled study.
Sure.
You talk to them and you see
Sure.
a paralegal, even a person
Sure.
that's willing to talk to you, say, what's enough?
Sure.
But my own experience has been, when I was in the public defender's office for a long time, we would just stay after and chat with the jurors. But then that became more of a formalized process for someone else that the office had either an investigator or a law clerk would do that. We had sort of a questionnaire, and I found a lot of jurors very willing to talk about the experience.
Yeah.
Oddly enough, my experience was more often the nature of the verdict controlled their willingness to talk to you. A conviction, I don't want to talk to you, and a acquittal, sure, I'll tell you what the government didn't have.
And the admonition to a judge, go ahead and ask the judge, would you, first of all, Judge Chevron, do you normally say, and I'll use him as an example because I've asked the now retired Jeff Chevron to instruct the jury as just that it's okay, that it's all right if the lawyers call you afterwards because they might be interested. And you don't have to talk to them, certainly, but don't be surprised. That really helps if you can get a judge to let them know what the law in Nebraska is, that after you're discharged, go ahead and talk to the lawyers. Again, if you're willing to do so, that helps a lot. Yeah, Eric.
Really quick, I in a civil case went out and tried it in Lexington, and I typically try to call the jurors myself, and I get what you're saying about having a third party do it. I'm glad though that I did in this instance because two areas of inquiry: one, what could we have done better, but then what also were the deciding factors in how the jury went. And in this particular case, the jury said, "Oh yeah, we looked at this diagram, and it turned turned out to be something that I had successfully kept out of evidence. And they should not have gotten it, but the bailiff did it. They gave Exhibit 23 when they should have kept it back. My opposing counsel, so I filed my motion. Opposing counsel agreed with me that we should get a new trial. And we settled it shortly thereafter.
Wow. Yeah.
So I'm not sure a paralegal would have been able to identify, especially somebody who was not in trial, that this particular exhibit was one. So,
Good point. I can think of one case where I actually had to be proactive, and I certainly did take part myself in that case in formally making requests to contact jurors and wanting to interview about whether something went wrong. I think that scenario of you being concerned about the process getting corrupted in a sort of way.
I wasn't particularly at the time I made the call, but I was glad that I did it later.
I'm not suggesting for a moment that you delegate that. You really have to be proactive there. I'm talking more about just the instructional, educational, informative process of getting juror feedback in situations where you want to just become, a better lawyer for trial next time. Okay, we've been given the 5-minute warning, and we don't want to overextend our welcome by the State Bar Foundation, our host. So I want you to ponder now the good concluding questions you can give as far as wrapping up candor in the courtroom and what we've talked about today. And we're looking to you all for that intuitive question. And Sarah, they can certainly call that into you, right, if they have an intuitive question out there. I do want to disclaim, all lawyers have to have a caveat and disclaimer. As a former adjunct, nothing, I said, where in the hell is Kevin Reuser? He was supposed to be here. Kevin was on there. All right. I'm going to call out Reuser and point out that nothing I said has anything to do with any of my experiences as an adjunct at the College of Law. Nothing I said has anything to do with my former work as an Assistant Attorney General to represent the state of Nebraska. And nothing I said has anything to do with my former role as on the Executive Council of the State Bar. This is my opinion and my opinions only, and certainly I do not suggest they be cited for any further authority beyond which thank you to the woman in the green jacket for asking me from time to time to give citations to authority that I hopefully left you with something that you can cite in future examinations of lawyer clients or opposing counsel or work with jurors. Any other questions or comment beyond the last 3 minutes that separated you from either enjoying the rest of a lovely Nebraska day or a baseball game at Haymarket Park against Northern Colorado, or it's too late for the end of Hillary Clinton's press conference, or other things that you missed because you had the need for the judicial ethical credits to attend the seminar today. So with that, good afternoon.